So continuing on, we'll talk about pension plans and health care a little bit. Okay, underneath employment laws, one that came up is the ERISA, or Employment Retirement Income Security Act, and that really monitors companies' pension plans, not so much like 401ks or 403bs, because those are funded and the employee takes responsibility, but pension plans are a little different kettle of tuna. There are not as many of them anymore. Companies are going away from pension plans and going to what we call defined contribution versus defined benefit. And so they don't fall as much under the purview of the ERISA. Consolidated Omnibus Budget Reconciliation Act, COBRA. We oftentimes mostly hear about this. In fact, you'll hear people refer to it as they're going to COBRA their health insurance. And what that means is that when you leave a place, if you've been covered by health insurance, you can maintain that health insurance that you had with your employer for up to 18 months. Okay, and you do have to pay the premium. Then the employer is not required to pay that on your behalf, but you can keep that, for the 18 months. So that's important for people in a transition, and maybe they're going to be off for a month or two. Or we had an employee, for example, at the bank who retired then when he was 63 and a half. He had a year and a half to wait until Medicare kicked in. He COBRA'd, our health insurance. He had to pay the premium, but it was good insurance, and it was worth it for him to do it. Health Insurance Portability and Accountability Act, HIPAA, talks a lot about the privacy that we have. Okay, and it's not just insurance, but because it talks about the privacy that we have in our health issues that we might have that come up at work. Okay, but it also talks about the portability of your insurance. And when you go to another place, and your acceptance, basically, regardless if you're working at a place, regardless of pre-existing conditions and whatnot. Employment at will. Okay, employees are either contractual employees or at will employees, and historically, at will meant, right, that they could be terminated for anything, any reason. It was kind of a tit-for-tat thing that an employee could quit a job anytime they wanted to for any reason whatsoever. They still can, okay? And an employer then could fire an employee, same thing, anytime for whatever reason, okay? Unless it's protected under an exception, okay? And that's what's happened now, of course, is that we have lots of those. And this is, and this was true as of last spring. I think it's still true. I haven't heard any other states that have adopted this, but Montana is the only state that defines wrongful termination. And what does that mean? That means that in Montana, for a covered employee, which is most of them, if an organization terminates that person, they had better have followed certain steps in order to do that. Okay, there's certainly exceptions. If an employee is stealing from you, you can terminate them automatically. If an employee is absolutely guilty of sexual harassment, you can terminate them immediately. Okay, there's reasons that you can terminate people immediately, obviously, but if it's poor work performance, let's say, you've got to work with the employee. You got to document this. You've got to provide the employee with opportunities to improve themselves up to the standard that you expect. Okay, you got to follow certain steps before you can terminate them. Otherwise, it will be deemed a wrongful discharge. It seems like a law that's more onerous than other states, but I've actually had people, small business people and whatnot, say that the law's not that bad, though, because it in a sense provides some legal protection. It gives you the guidelines that you need, that you should follow. If you follow those and ultimately the employee is terminated, the employee doesn't have a lot of things to stand on then if they do in fact sue you. It's their right to sue, because anybody could, but they probably don't have a leg to stand on as long as you followed the procedures. The implied promise of good faith is an exception for any at will. So we're out of Montana now. We're going to be talking about other states as well. And what does that mean? Well, there are states that are still considered at will states, and so technically an employer can fire an employee anytime for any reason. But here's the exception: there's this implied promise of good faith, that there's going to be dealings in good faith. So there's plenty of lawsuits that emanate from that. The employer acted in bad faith. Okay, so that's kind of the difference between our law and at-will states. And then there's some that are in between. They don't actually define wrongful termination. They don't actually set up standard like we do, but I think they're called for cause states. So people can be removed for cause, but it doesn't define it nearly as well as Montana's does. Okay, some wrongful termination, other wrongful termination things that do include discharge for performance of a public obligation. So if you're called up to serve, I think jury duty is another one. If you're called for jury duty, okay, discharge for whistleblowing, we can't do that just because somebody's telling on us. Discharge for exercising legal rights. Okay, if that's in the workplace, or discharge for refusing to commit a crime. It just seems like it makes a lot of sense. So if you asked your employee to commit a crime and they didn't, then you fired them. That would be wrongful discharge. Workers' privacy. Certainly there are personnel files, and certainly employees have access to those, but there's a restriction on third-party access to really anything that's in that. Okay. Private employers are generally restricted from using a lie detector for applicant screening. There are some exceptions to that. Companies that provide security, maybe that deal with the government and whatnot, can use lie detector tests under certain circumstances. Some states limit drug testing. Overall, drug testing is primarily it's categorized like this, that an organization can drug test anybody if they choose, in Montana at least, okay? But if it's not a safety issue, that drug test has to be on a schedule. So they have to give you plenty of notice, tell you when it's going to be, etc. If safety is involved, then drug testing can be random. Railroaders are subject to, train crews anyhow are subject to random drug tests. I imagine bus drivers could be, and airplane pilots, and people that deal with anything that involves public safety can be randomly tested for drugs. Workers' comp. It's a no-fault insurance, basically, right? It protects employees and families from job-related risks. It says the employer acted unreasonably, and that's not necessarily the case. Okay. It's kind of a no-fault thing. So if an employee is hurt at work, I suppose this is saying that just about anything you do that would cause you to get hurt is unreasonable. But even if you trip and fall and break your leg, okay, and it's kind of your own stupidity, but wasn't your intent, okay, you're going to be covered even if the employer didn't really act unreasonably. Okay, a test for compensation or injury does have to be accidental, so you can't self-inflict a wound. And it has to be within the scope of the employment. But remember, we've talked about that often and say that that's an extremely broad interpretation. We had a client at one time who was an outfitter, and one of his employees going out to where they were going to start the hunt that day, got in a wreck, and I can't remember wrecked into somebody else or what, but there was a lawsuit that came out of that, and then this was the person driving to work, or was the fact that they had to drive out there a part of their work? And ultimately it was determined that was a part of their work, and so the person, the outfitters, this wasn't necessarily a workers' comp thing, but it might have been. I'm not sure if there was a lawsuit from another car that was involved in the wreck, but in any event, even if the kid was hurt or the person was hurt, the worker was hurt, they'd have been covered under their car insurance and under workers' comp. It says it's an exclusive remedy rule, so when it is an employment thing, that's the only remedy that the employee has against their employer. If they accept that, then they can't sue. Okay, the FMLA specifically does not permit time off to travel overseas for the adoption of a child. That's absolutely false. Of course they do. Employment eligibility verification. So, yeah, this will probably be more important going forward. We haven't worried as much about it for the last 6 or 8 years, but now it's becoming a big deal. I don't think that I have any questions, or not many. You can ask an applicant if they are able to work within the United States. You actually are not allowed to ask them, are you a U.S. citizen? That would be inappropriate, but you can ask, are you eligible to work within the United States? Okay. So how do employers protect themselves? And this is some of the stuff. Job descriptions, of course, although, when getting back when I was in banking, and we had an attorney, HR attorney basically, and she told us, keep those kind of vague. The more vague, the better. If you try to make your job description so big and so complex, just about any time something happens with an employee, they're going to find something in that long, complex job description that you did wrong, and they're going to sue you over that. Okay, and so she was more a fan of keeping it a little more vague, a little short. Keep it vague. Of course, the language, and other duties as assigned, would provide some of the vagueness to it. Okay, same with personnel manuals, right? She felt the same way about that. Certainly, there's some things that you need to put in there, but again, if you try to isolate every single incident and try to account for that in a personnel manual, you're just kind of setting yourself up, this was her opinion, for failure if it comes to a lawsuit. Personnel files, these probably, and she would have encouraged you to keep documents, certainly if you were having any issues, and from the time the issue started. So if you had an employee, maybe even the first time they were late, you'd want to document that, okay? If it was an unexcused late or whatever. So, and with that, you might put in written warnings, but you could also just put in a note. If that person had been a good employee for 2 years and they just happened to show up late one day, you could write a note, so-and-so was late, and put that in there. And that, for a situation like that, would probably serve as documentation if, in fact, they started to come in late on a consistent basis. And letters of explanation then for the reasons that you're pursuing things. Again, if in Montana you're going through that wrongful discharge that discharge process, not wrongful, if you're going through that discharge process, explain why. Explain why this employee isn't meeting a standard then that you've set. So I think that's it. It is. So good. Well, we'll stop here, and then we'll be back to discuss labor unions here in a bit.